Hello, my name is Benjamin Hart. I'm an American attorney. I'm the Managing Director of Integrity Legal, a law office here in Bangkok, Thailand. In this video, we're going to discuss adjustment of status, the so-called I-485 process, and lift of conditionality. Adjustment of status in the family visa context with respect to, say, the Cr1 Fiance Visa occurs after the foreign fiancé has come to the United States and has married their American citizen fiancé, and then they need to go ahead and get long-term status, lawful permanent residence, aka green card. One must undergo the adjustment process. Unlike the U.S. immigrant visa categories, the IR1 or the Cr1, the K1 visa basically only allows the bearer to come into the United States for 90 days, and then upon entering the United States, if that person does not marry their U.S. citizen fiancé and file for adjustment of status, that alien must depart the United States or be considered an overstay of their visa status in the USA. Some things to keep in mind with respect to the adjustment of status process. The K1 Fiance Visa is a little bit different than the immigrant visas in that the affidavit of support that is filed on behalf of the fiance is actually an I-134 form as opposed to the I-864, which is used in immigrant visa cases. Once that fiance arrives in the United States and becomes the spouse of an American citizen, an I-485 packet must be filed, and included in that packet is generally an I-864, which is the affidavit of support. The affidavit of support involved in the I-864 in general and the I-134 is discussed in another video on this channel, but it should be brought up under these circumstances that the I-864 is filed at the time of the adjustment of status. Some things that people get confused about with respect to adjustment is the misunderstanding with respect to the Cr1 visa, the K1 visa, and the IR1 visa, and the various status that are granted under each one of those visas, and what adjustment actually is. Adjustment of status is having one's visa status adjusted from that of non-immigrant, i.e. K1, even though the K1 visa is what's called a dual intent visa, where the bearer can have non-immigrant intent as well as immigrant intent upon their arrival in the United States. But the adjustment of status, when you're adjusted, or when one is adjusted, they are literally, their status is moved from being non-immigrant to immigrant status. This is very different than what is called a lift of conditions, which occurs in the Cr1 category. The Cr1 in what basically stands for conditional resident. So a person who's admitted in the United States in Cr1 status is admitted as a conditional lawful permanent resident in the United States. The bureaucraties on that phrase is sort of astounding, because how can one be a conditional permanent resident? Well, the conditionality was created as a result of what was felt to be a plethora of so-called sham marriages, or so-called marriages of convenience, where there were instances of Americans marrying foreign nationals simply in order to get immigration benefits. The Cr1 visa category, or the conditionality of the initial immigrant visa issued to the spouse of a United States citizen who has only been married to that United States citizen for 2 years, was created in an effort to combat what was considered to be a problem with these so-called marriages of convenience. The result of this is, basically, if there's a U.S. citizen binational couple, an American citizen, say, married to a Thai citizen, if that couple has not been married for 2 years at the time of the foreign spouse's entry or admission into the United States in lawful permanent resident status, then that foreign spouse is considered to be a conditional resident. What this means is the initial green card issued will be a 2-year green card as opposed to a 10-year green card. And 90 days prior to the 2-year anniversary of that individual's entry in the United States, they will need to go ahead and file for lift of conditionality, which it's a fairly straightforward procedure, but basically USCIS wants to see the couple is still married and it's a genuine relationship. And once that is ascertained, hopefully in the positive, then a 10-year green card will be issued to the spouse of a United States citizen. So to sum up, there is a difference between adjustment And initially, the person who adjusts will be issued conditional permanent residence, and at the 2-year anniversary of that individual's adjustment, they will be able to go ahead and lift their conditionality and be granted a 10-year green card. So sort of, again, to sum up, the K-1 process requires that the person get the visa, then adjust, then later down the road, lift the conditionality of their lawful permanent residence so that they are then an unconditional lawful permanent resident in the United States. A Cr1 visa holder goes into the United States with lawful permanent residence, but the lawful permanent residence is conditioned upon the marriage staying intact for 2 years and basically a filing of a lift of conditionality. The IR1 category is for those couples in the marriage visa context. The IR1 category is for those couples who have been married for 2 years or more at the time of the foreign spouse's entry into the United States, and the IR1 grants unconditional permanent residence to the foreign spouse upon lawful admission into the U.S. with the correct visa. So an IR1 is basically unconditional permanent residence. CR1 is conditional permanent residence. K1 is a Fiance Visa, which is a dual intent non-immigrant visa that is adjustable in the United States, and upon adjustment, that person will be in conditional permanent residence for 2 years, and then until they file their lift of conditions, and then they become an unconditional permanent resident. With respect to naturalization, we'll discuss that in another video, but for now, those are basically the things to keep in mind with respect to adjustment of status and lift of conditions. It should be noted, with respect to adjustment of status in K-1 status over to green card status, while the adjustment is pending, the foreign fiancé, now spouse, cannot leave the United States without falling out of status. So if the adjustment has not been completed and that individual departs the United States, the visa process is effectively dead, and that person will have to go back through the entire process again to regain lawful status in the United States. There are exceptions to this. The filing of what's called an I-131 advanced parole application, if approved, will keep one's status during the adjustment process, will keep one's status, quote unquote, alive while that individual leaves the United States. In many cases, though, advanced parole is not heavily used. It's actually fairly rare to see it because one has to show a compelling reason for being granted advanced parole in order to leave the United States while adjustment is pending. Thank you.